Welcome to the Bankruptcy Matters interview series, organized and produced by the State Bar of South Dakota Debtor Creditor Committee. In this series, you will hear from industry experts on the South Dakota bankruptcy process and how you can be involved in a growing area of the law. Please join us and our host, State Bar Past President Steve Huff, to learn more about why bankruptcy matters.
In this session of our Bankruptcy Series, State Bar Past President Steve Huff interviews attorneys Laura Ask and Jack Nichols on their work for the Debtor Bar, advice for others looking to take on this work, including staffing and software needs, and the value of connecting with others to be successful.
Good morning. This is Steve Huff. This is a part of our continuing State Bar of South Dakota series for promoting practice areas of debtor creditor and bankruptcy work. I'm pleased to be joined by Jack Nichols and Laura Ask. I know, as a matter of full disclosure, Laura a little more than I know Jack from various years of having different cases together. I look forward to having that eventually with Jack as well. But in that vein, there is a great deal to talk about regarding the debtor side of what I would call bankruptcy or debtor creditor work. And so I guess I would start with Laura, and then I will go to Jack with the first question, which is if you could just describe each of you, your background, and then law school and or first jobs, and whether those were stepping stones for getting into bankruptcy or debtor creditor work. Laura, please let me know.
Certainly. Good morning, everyone.
Morning.
I started over 17 years ago. I actually started interning at the firm that I'm with right now in undergrad, and then went to law school at USD, graduated there, and was grabbed to stay at this firm. So I was very happy to select it there. I actually started in criminal law. Which is probably most people didn't know. And Claire Gary, which most people are very familiar with, is the one who sucked me into this side of the practice. And it's been very good since then. But started with him. So I've been with this firm for over 20 years and started here and still here. Very
good. Thank you. Jack?
Well, thanks, Steve. I was born and raised in Sioux Falls and went to O'Gorman High School. After that, I went to the University of South Dakota and studied history. Realizing there wasn't any history factories to go into work, I went to law school down at Creighton, where I earned my JD and MBA.
Oh, cool.
Right after.
Sorry about that. I was just, I'm always a fan of Creighton.
Oh, after law school, I came right back to Sioux Falls and started practicing with Lindquist and Benham, which is now Ballard. They were acquired by Ballard Spar recently. But there I was doing mostly transactional work and business work with some litigation. In 2014, I went to practice with my dad, Dan Nichols, and his longtime law partner, Steve Raybuck. So that's been that was quite a different transition because I kind of had to build my own practice up from scratch. We didn't have associates and many assistants and things like that. So that was a unique experience. And I really didn't start doing bankruptcy law until 2015. Both my dad and Steve got out of bankruptcy law back in 2005 after, the BAP CPA added additional requirements. And they're at that point where they didn't really want to learn a whole bunch of new tricks. So I kind of had to learn a lot from scratch, but it's been a fun experience and I do enjoy it.
I appreciate that. In fact, I think Laura and I have had several conversations comparing and contrasting our local rules vis-a-vis other states. And I understand that in and of itself. When I interviewed Judge Nail, he said, start with the local rules. Well, that's kind of like almost starting with a book, because if I remember right, it's almost 300 pages. And so did you find, each of you in your beginning of your transitioning into this practice stage, that was the right starting point, or was it more really the mentorship that was more assistive? Laura?
I'd have to say on that, probably a little of both. I was blessed to have Claire behind me, so that was kind of a big benefit for me. But the very good groundwork are the local rules. If you can get your head around those sooner in the game, you're going to have a much better chance of doing well in this practice and being able to converse with other experienced attorneys and not maybe feel like you're getting ran over right at the start. So it was a little bit of both, but mentorship is key. Especially in the debtors world, it's very much so an important issue to have. And a lot of debtors attorneys can't get into a firm where they would have a senior attorney that would be a mentor for them. But our bar is very good with the older attorneys or the attorneys that have been doing this for quite a while, funneling calls and emails and helping out and assisting the younger lawyers. They were for me, and I turn that favor around and do it for others because I've had senior attorneys that were there when I had questions. That really is a big benefit when you're practicing in this area. So mentorship's key, but not necessarily, I would say, in the aspect of being in a firm to have a mentor, but being able to reach out to that senior attorney. A lot of it's email now, but it works great because then you can converse with them at all hours of the day and get a response. And that's important. I mean, that's key for the young lawyers that are starting in this.
How would you respond to that, Jack?
I would agree. I think the two mentors I had were 10 years old. My law school, that was one of my favorite classes in law school was bankruptcy. So I thought I had it fresh in my mind. And, I'd look through these practice guides and I thought everything kind of made things deceptively simple. And I kind of had to learn the local rules by crash course. So I wished I would have reached out more. Like Laura said, Laura's been extremely helpful to me, the other attorneys as well. So I wished I would have reached out more for just basic questions because if you don't have a good mentor, you can almost be deceived into thinking that, well, this is how you do it, or it's more simple than it seems. But the local rules tell you exactly how to do it. So, and of course, the clerks are very helpful and provide a lot of assistance with that too. So I wished I would have, before I even touched the case, just sat down and gotten through it somehow.
Yes, I agree. Well, let's transition a little bit from the how you got here to now that you're here, how does it work? I'm looking at my list and I see that there are, suggestions about what is the most important thing that happens in your respective practices during the debtor's initial visit with your office. And I'll start with Laura.
Probably the most important thing that comes out of that initial meeting is getting a big overall picture of what's going on for your client, for the debtor. They sometimes have a multitude of issues that are coming into play as far as why they're in your office and why they have to be looking at some type of restructuring option or bankruptcy in itself. So you kind of have to listen very carefully to your client and help determine what that overall big picture is, because once you're able to establish that, you can put together a roadmap for them as far as this is where you're at, this is where we're hoping to get you to. And the main thing about that first initial meeting is to help that client realize that there is light at the end of the tunnel. When they come to us, they're in a pretty dark spot. Usually almost every single one. They don't want to be there. They've got a lot of things that they're juggling. So they need to see that there is something, whether it's maybe not what they initially thought coming in, but something at the end there that they can reasonably obtain, and that you're going to be able to show them the process and help assist them through that to obtain it. That's kind of the key of that initial meeting.
And Jack, what would you offer in terms of your initial meeting with clients? How does that work, and what's most important in your initial dialogue with the client?
Well, one thing that I try to get better at is giving clients a little bit of my time just to tell their story, because it took me kind of a while to realize exactly how embarrassed and kind of overwhelmed people are. And people put off meeting with a bankruptcy attorney for years and years, and they read a bunch of disinformation on, Dr. Google. So Google Esquire so that they have all these thoughts in their heads. One thing that I really learned to do is make meticulous records of things I tell clients in that initial meeting, because I would get responses of clients saying, you never told me this, you never told me to expect this. And of course, I have, and I think it's really important to have a checklist to make sure you ask and get a good one, to make sure you ask all the right questions so you don't miss a major issue in that consult when you go back and do the case and you don't know what your client's talking about when they're bringing up an issue with a mortgage or a lien. And then I always send up a follow-up letter saying, I can't explain everything to you in a consult. There's just a bombardment of information you're going to get. So here's some points, A, B, C, D, E, F, G, H, I expect this, we need this. You have to be complete and honest and transparent with us in the court. And just a lot of, I know it's kind of a cover yourself approach. I've gotten burned several times or had clients conveniently or genuinely not remember me telling them something very important.
How about with the, I anticipate that in this field, both of you have faced the clients that just kind of gave up from an organizational standpoint and just bring you a box of stuff. How do you break that out so that you can eventually develop the kind of record keeping that you need to do the bankruptcy schedules and prepare the initial documents so that you can assist that client from the initial sit down process to the beginning of the more formal court process? Laura?
That's actually, unfortunately, sometimes more common than not, that we get a shoebox or we get a big stack of unopened mail that they just can't face opening and looking at it anymore because it's just too much stress for them. Or just a tub full of different things, and it may not even have everything in there that I need, but it's got, and other things I should say in there that I don't need. So our staff has been pretty good as far as trained in going through and picking out those documents that we need from those categories. And then we have our own filing system that we personally use in our files to organize those so that it's easier for anybody in the firm here to access those documents in our internal files. But we do maintain copies of everything that's relevant, of course, to keep in our files. So you spend a lot of time sometimes going through, and by you, I mean for solo practitioners right away that are starting out and can't afford staff, sometimes that's you as the attorney going through that, stacking it and organizing it. Once you get to where you can cash flow it a little bit better, then you'll train staff that can actually pull those documents out. And part of our process as attorneys is analyzing and reviewing those documents and then maybe adding to them because we're missing certain things. So doing a list of things that we need to obtain in addition from the debtor, but that is very common. So you get pretty good at organizing and thumbing through quickly and seeing what you need of those documents.
Jack, how do you get your clients through that record preparing process?
Yeah, I've seen everything Laura's talking about 100%. And I used to sit and sort through just not even shoeboxes, sometimes bankers' boxes of documents and just trying to make sense of them. But I have to give a lot of credit to my assistant, Jenna, because she's sometimes tougher than me and will tell people, you didn't fill out half the questionnaire you gave us. I told you to give us these documents, and she'll just send it right back and say, just bring this to me when it's complete and accurate. So I've gotten better at telling people over and over, even in the initial consult, and I give them a packet to fill out and they, signed an agreement and saying, just sit down and take the time to collect the documents and bring it in all at once. And we'll get your case moving much faster and much smoother. And we will put you at the top of our list if you give us everything you need, or everything we need. And then I profusely apologize for how much work it is and say, I don't want you to have to find this much information. I just have to have it. Our hands are tied. I cannot file your case until I have this stuff. And so I just apologize in advance, and then Jenna kind of gives them the tough love by saying, nope, send this back. You didn't do a good enough job. So credit to her on making my life much easier.
And I'm going to take a question a little bit out of order on the list and go directly running to the light of the topic of support staff. What kind of support staff do you now have? How did the training go? And what was most helpful for them and you in that training and then working with client process? Laura?
The support staff I have one certified paralegal, a certified, not just a standard paralegal, but actually a certified paralegal is important for a debtor's attorney in the federal courts because we can't bill for their time if they are not certified. So a lot of the paralegals that we hire really don't have that certification. So we usually have to get them through that program, and our firm does that for our staff so that we can get them certified. The reason why we certify them is there's certain things that our staff can do that is a lot more cost effective for our clients than us doing those. And we'll bill at those hours to save them the money and the cost and expense through these reorganizational processes, usually the Chapter 11s, Chapter 12s, those type of things. But I have one certified paralegal that works with me, has been with me since I trained her right out of undergrad. So 10, 12 years is what she's been with me. And then I have another new paralegal who's looking to get certified, hitting the ground running. And then we have my partner, Claire, also has his own certified paralegal on that side. And we have a receptionist that does some of our organization and data retrieval and things like that too. So we're blessed enough to have kind of an established, built up to have good support staff. In my opinion, my staff is great here. They're key. I can't thank them enough, but they're crucial for you to be able to minimize those costs to your clients and make it a little more profitable for your law practice. And training them in the bankruptcy world is a little bit harder than just taking a paralegal that's been doing civil law or state law, contract law, criminal law. You have to add a lot of time with them initially and get them up to speed. And it does take them a couple years to actually be fully there. So, we run into that every so often when somebody decides to take a different position, we'll retrain. But the key thing is if they can come in with some type of foundation, good grammar, good writing skills, good legal, sound legal knowledge or sound legal terminology, a good basis for the legal terminology, that's a whole different thing. It really helps your practice as far as for them doing your dictation, just maneuvering in the system itself to file things or understand the process when they're talking to clients. So that's kind of key when we're looking for people to have those standards. We can train the rest. The rest with the bankruptcy side, we can train them, we can get them up to speed. It just takes time.
And Jack, how do you steer people, staff through that process?
I think for me, it's just kind of a matter of time. I mean, they can't, like Laura said, there's so much more than just, your assistant helping you draft an operating agreement or a contract. There's just so many concepts that are really hard for people who haven't, even for like lawyers who don't do bankruptcy law to understand, and it took practicing bankruptcy attorneys a lot of times. So I think it's just time and patience. And a lot of times there's good training webinars you can find, practice softwares oftentimes have a lot of assistance for just, if you can simply comprehensively do data entry and just kind of understand what documents need input stuff, you can save the attorney a ton of time. So I just try to teach them myself one day or week or month at a time, something new, and help them understand things so they can, better see what I'm doing on my end.
And that's a good next topic raiser, Jack, is the issue of, what kind of software or other legal resources do each of your firms utilize to help with petition schedules and motions practice? And I guess I'll start this round of questioning with Jack.
Well, I started with Best Case, and then when I hired a part-time assistant just for my bankruptcy practice, essentially. I mean, she did other stuff too, but we really liked Best Case, but I moved to Next Chapter because it's browser-based. So we could both be working on the same petition, and it flows pretty seamlessly. I don't know if there are many attorneys in South Dakota that use Next Chapter, so they're still working with us to customize things. And our jurisdiction requires a lot more customization than other ones, I assume. At least their support staff seems to think so, but they do work with us. I did really like Best Case, though. I thought that was extremely logical and helpful in how data is entered and how something on one schedule correlates with another schedule. I thought it was a little bit more seamless, but you know, having the ability to, if they ever went browser-based, I'd probably go back, but it's just too convenient to be able to be working on it with different devices simultaneously.
And Laura, what kind of software do your staff use and Claire ignore?
Claire ignores, yes, that's probably very key there.
Say them.
Yes. The software that we currently are using is Encompass, and we've been using that one for quite a while. We used to use Easy Filing, and that seemed to be the common one in South Dakota for most practitioners to use, but Easy Filing stopped supporting and actually producing that a few years back. So we had to look at a new program, and really Encompass was kind of the most similar one for our staff to transition to, so it was an easier jump for everybody. Encompass is a good program. It's got its tweaks. You know, we're still working on those too. Multiple times where it'll do something, flag something on a schedules, and because of an update, and we don't even know how it got there until one of the clerks call us and say, why is this showing this on your petition now? Well, it was an update done by our software system. We're working on it. You know, it takes a while to do it. I think you're going to have those glitches anywhere with any software system you're using. Ours is web-based, so just like Jack said, it's really great because my staff can be working and I can also. The difference with these that we found is that you find the one that's cost-effective for your practice. For how many, because some will bill you by the number of filings that you do, some will bill you a flat monthly rate, and there's different billing methods that they'll do. So you find which one works for the number of filings your firm is going to do. And that's cost effective. That's how we picked ours, and also one that's user friendly and well supported. With all the changes that we do with bankruptcy law, you're constantly getting updates. So you have to make sure, and I use well supported lightly, but you're well supported customer service to try to help technical support with those type of issues.
Okay. And as far as the rates go, without discussing particularly your individual hourly rates, how are they set? And is there, I expect, a range of rates that are true for the debtors bar and also true for the creditors bar? And I'm guessing it's kind of like a Venn diagram. They intersect, but they're not identical. Can you talk about that, and then perhaps even discuss the approval process for those rates through the bankruptcy process? And I'd start with Laura for that discussion.
There is a huge range. Young lawyers that are starting, and I'm basing this off of when I was a young lawyer starting, and I'm still a young lawyer. Thank you, everybody. Yes, but not really. I mean, I've been doing it for over 17 years. So, but you know, when I was looking at the starting range, that ranged somewhere around roughly 150 an hour. I'm sure that has gone up a bit for young lawyers, but for debtors, this is only debtors counsel I'm talking. The high end of that we've seen in the state of South Dakota is probably right around that $350 an hour range for the well-seasoned, experienced attorneys. But that's kind of the range that you're in, and it adjusts with your experience, your knowledge, the difficult levels that you're handling with these cases. That's how it adjusts. As far as creditors attorneys, I don't know for sure. I mean, they run within that range. I do know there's creditors attorneys that bill way more than debtors attorneys because in all reality, their clients can afford that. Our clients can't. We need to stay in a reasonable rate for them to make it affordable to them so that they can actually do the process. So we'll never be to that higher level in the debtors world, which if you're in it for the money, then definitely not the high hourly rate in the debtors world would be my suggestion. Approval process is also different in bankruptcy court. The debtors attorneys need to get all their fees approved by the court. Creditors attorneys do not. So when we file like restructuring through Chapter 11 or restructuring through Chapter 12, or even just a consumer Chapter 13 bankruptcy, we do need to disclose on the onset what we approximate our fees to be for that. They are not flat. Usually they're hourly. And then we also, at the end of the case, have to get approval for those fees, what they actually were overall. So we submit a detailed itemization which in a chapter 11 or chapter 12 long extensive one, you can guess that it's pretty long detailed information as far as every single minute we've spent on that case, and that we're asking the court to approve our fees for, so that we can actually get paid. We also, as debtors attorneys, are required to hold that money in trust and not be able to use it for our monthly expenses, our payroll, anything like that, until we file those applications for approval of those fees and the court approves them. You can do interim ones if you've got a long case, like a long chapter 11, you could do interim ones to get that if you need it, but you absolutely cannot use those funds until you get that approved through the court, and then you can use them for your operating expenses. That's a big difference between debtors attorneys and creditors attorneys. Creditors attorneys don't have to do that.
Jack, do you find that's about the right description and range of attorney rates and how you weed through the process of court approval?
Yeah, that's spot on, because I routinely go on CMECF and look at everyone's rates. So I've seen, I think every attorney who's done a case in the last 2 years, I've meticulously looked at their rates. And I don't do that to be snoopy. I do that to figure out where my rates should be. For various reasons, you know, I try to be on the higher end. I don't think it's economical at all to be a everyday low service provider in consumer bankruptcy. I think the attorneys, for the amount of knowledge and experience, way undercharge for how much time you actually spend on the case. Some of these dockets have hundreds of findings. I mean, even a simple chapter 7 can have 45, 50 docket activities, whereas someone will charge $5,000 for a simple divorce where there's 8 docket activities in state court. So yeah, the process is the same. I've had chapter 13s where I've worked on from the day I met with the client till over a year before I saw a penny. But you got to do everything right, because they do look at it. You have to make accurate and concise time entries. Judge Nail's got a lot of cases out there to look at. And I've had fees just scratched off. And so I learned sometimes the hard way to got to do everything by the book with fees, and got to get the court approval, got to adequately disclose. But as far as the rates are concerned, I'd say Laura's right on for exactly what I've been seeing.
The largest rate I've ever seen Judge Nail approve was in that Randall Kent Hansen chapter 11, and I think it was just over $600 an hour, and that's the top rate I've seen. Typically, I think the ranges you both discussed are well within my experience of what debtor and creditor rates are. And you know, you can not only get on CMECF and check, you know, debtors and other rates that are approved by Judge Nail, but you know, in federal cases, I had one recently in front of Lang where I made application and it was challenged. We actually had an evidentiary hearing on the rates with the bills, and that's always a delight. But you know, it's good to be scrutinized, and it's even better when you're told you're doing things the right way. And you know, it gives you pause, and it helps you with your practice as far as, you know, how do I keep track of, you know, in block billing, do I block it or do I sub block it so people know exactly what time went into this 2.5 hour entry in the day? So, you know, to each their own, but I think that's an important thing that helps with debtor approval of fees and creditor approval of fees, which I think happens, albeit not nearly like the debtor practice, but still is an important lesson to keep in mind, so you don't end up with, you know, perhaps the scratching off, or worse, not getting approved on fees, which I've known has happened on occasion from time to time, even in front of Judge Nail. Tell me a little bit about the non-chapter 7 practices, as far as I think both of you initially discussed in the beginning questioning a little bit about, you know, trying to get your clients at ease and also paint a big picture for them, which I assume in part is, you know, Laura's transitional phraseology was something along the lines of, you know, where we are and where we're going to get to, which is almost, in my mind, trying to create a, here's the finish line, and once we cross it, this is the objective. This is what this process is meant to do for you over time. How do you have those conversations, not just at the start, but also in the interim, and then once either discharge is granted or the case is closed, how do you continue to work your clients toward that finish line? Laura?
That's actually a really good question, because that changes throughout the process. And it whether it's at the fault of the debtor or not at the fault of the debtor, a lot of the times it's not. It could be the economy, it could be a whole multitude of reasons why that roadmap essentially changes for them. And each one's a little bit different. So when we're looking specifically at a Chapter 11 for a reorganization of a business, or a Chapter 12 for a reorganization of a farm or ranch, then we're looking at a longer term. We may start out initially analyzing to see whether it's feasible for them to realistically be successful in that reorganization. If it's not, you're doing your client no favor by putting them through that, because it is a long process for them. It takes a lot of years off their lives going through a reorganizational process in a bankruptcy court. So if they have no reasonable likelihood of succeeding, we don't put them through that unless they fight us tooth and nail. But majority is it's not feasible. We can show them alternatives then, as far as maybe partial liquidation, different things that we might be able to do prior to then restructuring and letting them keep certain aspects of that operation. So it could start out where we go into a case fully seeing it as a reorganization, and then in the midst of it all, something comes up to where it's not going to be obtainable either to confirm it, or even after confirmation, something changes. There's a change in circumstances that takes place for the debtor, or something else that impacts the debtors, to where we need to even modify it post-confirmation. So that's an ever-changing cycle for the debtors. It's not from the start, this is where you're going to be, and at the end, this is exactly what you obtained as we initially predicted from the beginning. And that is one of the great aspects of being a debtor's attorney. There is not one case that is the same, not one. You will always have something unique that comes up in every single one that keeps it challenging, keeps it interesting, keeps you driven as a professional to keep improving your skills and updating your knowledge in this area. So you're always counseling them along the way. And when we confirm a case, it may be that they start out kind of back on their own, operating in the ordinary course, but there's many times after confirmation that the debtors reach back to us because of certain things that have come up, to either ask questions, to have a motion filed, to get a certain approval done. So we're still in contact with them. It's just in a much lesser extent after confirmation than during the actual bankruptcy process itself.
Jack, how does your experience track with those kind of what I guess Laura is describing as evolving or moving goalposts in, whether it's an 11, a 12, or a 13, it's whether it's by health or change of job or other kind of cash flow issue. How do you work your clients successfully through those hoops?
Well, I've even seen in the short, I think with reorganizations, and I don't do any Chapter 11s, but even in a Chapter 13 context, just getting a picture of a person's projected future income is almost impossible. I mean, people change jobs, get laid off. It's not 1976 where you go and work the same factory your dad did and you work for the union, you have the same job, and you retire. I mean, people's lives are vastly changing. People leave the jobs and go back to school. And just the amount of debt people have is so high, and the types of debt, and they might have an upcoming surgery and you don't know if they're getting a $100,000 bill. So just kind of figuring out what people's future is going to look like over 5 years, I think as our lives just get more complex, becomes a more difficult challenge. And just people's working arrangements and things of that nature have changed so much. Even in the time I've been doing, I can't imagine how much different it was for debtors reorganization attorneys back in 1976 when they did the first reform of the bankruptcy code. I think I have that year right, but yeah, times have changed and the code hasn't quite kept up, but I don't really know how you can. You just got to do the best you can to make something work and make it be feasible over 5 years or longer if you're doing, a different type of reorganization.
I am a frequent critic of Congress, but I think they actually got one small thing right in 2019 by raising the rates on Chapter 12s from the kind of graduated, at one point it was 4.135 million to 10 million, and then also developing that interim small Chapter 11. I think, as you've stated, they have not caught up with the times, but at least there are portions of legislation that have helped, as opposed to, I think, what you referred to in 2005, which drove a lot of people out of the debtor creditor and bankruptcy practice, that BACPA litigation and legislation that ultimately put a lot more hoops out there for what I perceive to be debtors practice, not just in terms of reaffirmations, but also just, means testing and all the things that you now have to do from 2005 onward, as opposed to what went on in 2005. Do you find that changing evolution of the law is the most difficult thing that you each face in debtor bankruptcy practice, or what would be the most challenging thing that you've at least seen as of late? Laura?
It is challenging. I wouldn't say that ever-changing definition is the most challenging aspect of debtors law. For me personally, and that's a personal one, the most difficult thing is when you can't legally do anything for the client and you have to have that tough conversation with them as to why their fourth generation farm is not going to see the next generation, or as to why they have to give up the homestead that their great-great-grandparents built. I mean, to me personally, that is the most challenging aspect of what we do. I like to make sure that if I can get in there and fight and they can make it work and they can survive, we can give them that opportunity to do that. It's when we realistically can't, and there are a few cases where that does happen, where we realistically cannot, because of their financial situation, it won't work. And then that difficult conversation you have to have with them is probably the most challenging part of being a debtor's attorney.
Jack, how do you feel the most challenging aspect for your particular practice area? What is that and why?
Well, I suppose this is kind of my personal opinion, is that I think the fresh start concept that was originally intended has kind of been whittled away. And just to kind of echo what Laura was saying, you run into situations where the only solution you have for your client is not a good one. And there might be a slightly better solution that doesn't look good. I think that kind of ties back to my original point that people's lives are so complex, and people have not $70,000 in medical debt, but $400,000 in medical debt. And people don't have $20,000 in student loans. They have $250,000 in non-dischargeable student loans. And some of these people get so far behind in child support and things of that nature. I understand why Congress would want to make that non-dischargeable, but just run into situations where people are going to, it's a life sentence. Some of these debts are free bone. There's just not enough tools in your tool chest to get people that fresh start.
Yes, I tend to agree. What words of wisdom would each of you offer for new practitioners in law generally, or those that had left the practice, as Jack had described, somewhere in that 2005 range, to come back to the bankruptcy debtor creditor practice? What words of wisdom would you give to people that are considering joining in a practice area that's going to have the kind of influx of work I think we all expect based on COVID and the farm economy? Laura?
Well, from a debtor's attorney, my opinion is that the debtor's bar is a very highly overlooked category of the law when new practitioners or other practitioners are looking to get into it. I honestly would not have got into it myself if it wasn't for Claire. So I would not be here doing it because it wasn't something that was a highly sought career when we were going through law school. But for anyone who's looking to join, it is certainly a very unique niche of the law very complex, very challenging, which is great for me. I love a fight. I love the challenge. So if you don't want the mundane, everyday type situation, this is the area for you. We are a very small bar. We are on the onset, mostly all of the attorneys, whether they're on the creditor side or on the debtor side, get along very well. It's a very close niche of attorneys, and very good attorneys. I mean, Steve and I face each other almost weekly on the other side, and we go toe to toe hard, both to adversely help our clients, but I consider Steve a good friend. So you meet a lot of really great people in this bar, but anybody looking to practice doesn't necessarily jump to this one right away, because it doesn't get the glory of all the other areas of the law. You can make a great career doing this. You can become one of those unique specialists in the area where you're not just doing the bankruptcies, you're being hired to be an expert in a divorce case regarding the financials of the individuals, or regarding the financials of the business that's involved in that divorce. We spend multiple times going into state court being experts, where we're testifying to these skills that we've learned as debtors attorneys and helping in that area. So you're not just in the bankruptcy arena every single day. But it really is a great profession to be in. I mean, you can't pick a better one that is more challenging. And even on the creditor side, even though I don't do the creditor's work, it's challenging. There are a lot of things that you need to take into play with that, and it's never boring. But from the debtor side, we get to fight for the underdogs. I love fighting for the underdog. So if you as a practitioner like that fight, put your time in, study the local rules, get a couple seasoned attorneys that you can befriend and kind of ask those questions to help you in those circumstances where you just really aren't sure what you should do before you file that case, so that you have a good idea, and jump in. It's a great profession to be in. It's hard. We work hard, all of us. We put our long hours in on both sides, but it's a great profession to be in.
Jack, what do you think is the best words of advice you can give to someone considering joining the debtors bar or the bankruptcy debtor bar?
I would say get to know the other attorneys in the bar right away. It is kind of like a small town practice, and that we all see each other and know each other and see each other's petitions and Judge Nail's opinions on our cases and things like that. So people are very willing to help. I would also say make sure to not, well, unless you have the resources and the staff and the marketing budget, don't be the Walmart. Don't try to win over a client by not tracking for your time, or it's just not going to make sense from a law firm economic standpoint. You know, it's better to be able to give the client the resources and time that they deserve by being able to charge a little bit more, and they'd be willing to pay more if they can too. But don't push the envelope too far. It's going to be scrutinized, but make sure that you're compensating yourself and giving yourself the incentive to be the best advocate for the debtor. But yes, I would also reiterate, just sit down and get through the local rules. Even if you have to drink a pot of coffee and stay up all night, that would save you a lot of time and a lot of mistakes that need to be corrected in the long run.